Good afternoon. My name is Kate Shank, and I'm the Deputy Director of Legal Aid Chicago. Welcome to Legal Aid Chicago's 6th session of our series, Finding Solutions, Legal Aid for Our Most Vulnerable Populations. Today's session will focus on the unique needs of families who live in subsidized housing and how legal aid can help. Now, to get us started, I'd like to turn it over to the host of today's session from Kirkland & Ellis, Aisha Lavinier. Aisha?
Thank you, Kate. Hi, everyone. Thank you for joining. We hope that today's session is informative and interesting, and you get out of it whatever you came for and more. My name is Aisha Lavinier. I'm a board member at Legal Aid Chicago and also a partner in the private equity M&A practice at Kirkland & Ellis. I've been on the board with Legal Aid for only a short time now, but I've been familiar with the organization for a while as my firm has a long-standing relationship with Legal Aid. Over 300 of our attorneys have worked on different matters with the organization. We spent several hours working on these matters, but you know what, it's nothing compared to what the people there at Legal Aid have dedicated their time to doing. And what I've come to see, and what you've always known is important, but what I've come to see with the organization is just the pervasive issues that we all see and know and face them for ourselves. The importance of kind of civil legal aid and leveling the playing field and getting justice at the end of the day, how important it is to have organizations such as this one. And the topic today, families living in subsidized housing, is right up there with, I think, all of the important, of all the important areas, one that's very obvious, very pervasive, and very prolific issue. So with that, I'm going to turn it over to those who are the specialists in this area, and we're going to hear from today. First, we're going to have Marshall Gardner, who's a senior housing coach at Employment Employer Services. We have Carrie Beyer, a senior attorney in the Consumer Practice Group at Legal Aid Chicago, and also Catherine Panella, who's also a senior attorney in the Housing Practice Group at Legal Aid. With that, I'm going to turn it over to you, Marshall, to get us started.
Okay, sorry, can you hear me?
We can hear you, and now we can see you.
Now I can see me. Thank you, Aisha. Okay, as Aisha stated, my name is Marshall Garner. Good morning, everyone. My name is Marshall Garner. I am a program manager of housing with Employment and Employer Services. I work directly with residents in subsidized housing, and I have been doing it for a very long time. Ranging from being a property manager, regional property manager, to my current position, which is program manager of housing. And I just want to briefly touch on 3 areas that I do believe will help residents of subsidized housing transition from that to self-sufficiency. Okay. And the first area I chose to speak on was mindset, and I chose that first because I know that our thinking must be correct for the goal we're trying to achieve first, and then we can go about taking the steps to achieve that goal. Subsidized housing, was meant to be a stepping stone, a temporary stay, somewhere you can, get on your feet until you can move on and do better and achieve self-sufficiency. So what we try to do is encourage residents to think about the goals they want to obtain, to start them thinking proactively about that so they can start thinking about what steps they're going to have to take to achieve that goal. We suggest using available resources that are at their disposal, such as our Family Works program, which I'm a part of. And in that program, we have everything from youth programming to senior programming to rental assistance to advocacy with the landlord, being a liaison between the resident and the landlord, and even much more. And we also want to encourage them to educate themselves about the different policies and regulations that affect them. They want to know about the policies that govern them and their obligations, as well as the landlord's obligations. Slide. In the family assessment, when we assess, we try to assess the family as a whole and do it holistically to try and establish cohesiveness within the family and get everyone trying to drive in the same direction and try to have goals that move the family as well as the individual to a self-sufficiency area. And we let the family drive the process. So we kind of might encourage them, but we let them come on out with the things that they believe actually will get them to that goal. And in the family assessment approach, we might find out some things about the family that can demonstrate a need for clinical services, which we have, or legal interventions. And of course, we would be referring to legal aid. That's our go-to legal entity. Okay, slide. Employment, training, and education. So this is very important. We know that employment is a huge factor in achieving self-sufficiency. Our agency prides itself in employment and helping people to get jobs. And as well as just getting employment, if a person needs training or some assistance in getting ready to hit the job market, we support them in that as well. All those resources are available to our residents in subsidized housing. So we really encourage them to make use of it and to make it be something that they can take advantage of. And as well, we do talk about education, and we stress the importance of at least finishing high school, obtaining a diploma or a GED. And of course, we support moving on to secondary education, and which we would like for them to do if they're actually interested in that. So these are some of the three things that we feel will lead to self-sufficiency if implemented. So with that being said, I'm going to turn it over to Catherine Pinella. And thank you all very much for your time.
Thank you so much for your valuable perspective, Marshall. My name is Catherine Pinella. I'm a senior attorney in the Housing Practice Group at Legal Aid Chicago. Thank you all so much for joining us today for our discussion about the client population that the advocates in the Housing Practice Group serve almost exclusively, which is families in subsidized housing. Marshall discussed assisting families in subsidized housing with achieving various goals and ambitions. At Legal Aid Chicago, we recognize that none of the other goals a person might have can be achieved if their housing is threatened. So we specialize in assisting low-income families in remaining stably housed. To begin today, I want to discuss the context in which we're having this conversation. You've undoubtedly all heard in the news over the past year or more about the impending eviction crisis that's being predicted as a result of the pandemic and the corresponding recession and high rates of unemployment that have made it impossible for many tenants to keep up with their rent payments. Over the course of the last year or more, various measures have been enacted to attempt to curb or forestall those evictions while the public health crisis was at its peak. First, the Federal Coronavirus Aid, Relief, and Economic Security Act, or CARES Act, was passed at the end of March 2020. The CARES Act included an eviction moratorium, which applied only to tenants in federally subsidized housing and prohibited eviction filings based on non-payment of rent. That moratorium expired in July 2020, though, leaving a vacuum of protection in many places throughout the country. After that, on September 4th, 2020, the CDC issued an order halting residential evictions of, quote, covered persons, essentially anyone who has been unable to pay rent as a result of a COVID-related financial hardship. The CDC order has been extended multiple times and is currently set to expire on June 30th. The future of the CDC moratorium is uncertain, both in terms of whether it will be extended past June 30th and because it is facing increasing challenges in the courts. Unlike the CARES Act moratorium, the CDC order covers tenants in all rental housing in the country, not just tenants in federally subsidized housing. The last pandemic-related measure that is significant for our purposes is Governor Pritzker's eviction moratorium, which has been in place in some form since March 2020 and currently expires on June 27th. Illinois' eviction moratorium is based on the governor's emergency powers, and as a result, has had to be reissued in approximately 30-day increments. In May of this year, Governor Pritzker signaled that he expects to phase out the statewide moratorium by August. The good news for tenants is that after the most recent federal stimulus bill was passed, more than $1.5 billion in rental assistance is being made available in Illinois. And we hope that those funds will make a real difference in preventing mass evictions in the state. However, the thing to recognize is that the eviction crisis is not only a new or COVID-related phenomenon. Those of us who practice in this space are keenly aware that evictions have been a crisis in the United States for years. Before the pandemic, approximately 30,000 evictions were filed in Cook County every year. The vast majority of those were filed against low-income people, and many were filed against families living in subsidized housing. Now, obviously, an eviction is a terrible thing to happen to any family. In the housing practice group at Legal Aid Chicago, we have focused our practice on subsidized housing because we recognize that even more is at stake in subsidized housing cases than in an eviction from market rate housing. There are several reasons for this. First, the rental assistance that a family in subsidized housing receives often runs with the unit, meaning that if a family is evicted from subsidized housing, they lose not only the housing itself, but also their subsidy. Secondly, tenants in subsidized housing often have what is colloquially called an endless lease agreement. That is, in many subsidized housing programs, a family's tenancy cannot be terminated without good cause, making their tenancy in the subsidized apartment that much more valuable. Finally, tenants in subsidized housing are likely to become homeless if evicted. This is because tenants in subsidized housing have to be income eligible for the subsidy, meaning that subsidized tenants are by definition unable to afford housing in the private rental market. Now, contrary to what is perhaps the common perception, tenants in eviction proceedings often have meritorious defenses to their eviction cases. I'm not going to go into detail explaining all of those possible legal defenses, but I've listed several on the slide here just to make the point. In addition, tenants in subsidized housing often have rights and remedies available to them that are specific to the subsidy program that they participate in. However, what the vast majority of tenants in eviction proceedings do not have is a lawyer. And a lawyer is really essential to effectively assert the defenses that are available to a tenant in eviction court. The last thing that I want to note before we get into discussing the various subsidized housing programs that we deal with is who lives in subsidized housing. Often, families with young children live in subsidized housing. There are also many senior citizens in subsidized housing. In fact, many subsidized housing developments are specifically for seniors. Many families in subsidized housing also include household members with disabilities. In short, the folks living in subsidized housing are often particularly vulnerable and particularly in need of assistance and protection. I now want to spend some time giving you an idea of the types of subsidized housing programs that are out there, because they may be more numerous and varied than you realize. The first major subsidized housing program that I'm sure you have heard of is public housing. Public housing is housing that is owned and operated by a public housing authority, or PHA. In Cook County, there are actually several public housing authorities. The big one that I'm sure you've all heard of is the Chicago Housing Authority, or CHA. But there is also the Housing Authority of Cook County, or HAC, the Oak Park Housing Authority, and the Park Forest Housing Authority, among others. Public housing authorities contract with the United States Department of Housing and Urban Development, or HUD, to provide public housing directly to low-income families. In public housing, families typically pay 30% of their monthly adjusted income in rent. The rental assistance runs with the unit, meaning that if a family leaves public housing, they lose their rental assistance. Finally, families in public housing have quote unquote endless lease agreements. Their tenancies may be terminated only for good cause. The next major bucket of federally subsidized housing out there that you might not have heard of is known as project-based Section 8 housing. This is actually an umbrella term. There are several programs that exist underneath this umbrella. Here, a private landlord contracts with HUD to provide subsidized housing to low-income tenants. In this type of housing, there is no public housing authority involvement. A tenant's rent is calculated similarly in project-based Section 8 housing to how it's calculated in public housing. It should be 30% of the family's adjusted monthly income. Tenants again have endless lease agreements, meaning the tenancy cannot be terminated without good cause. And again, the rental assistance runs with the unit such that the tenant loses the assistance if they move out. The third major subsidized housing program is the Housing Choice Voucher Program. In the voucher program, a public housing authority contracts with a private landlord to subsidize a family's tenancy. The tenant's rent is again calculated similarly, 30% of the family's adjusted monthly income. But this is a tenant-based subsidy. The voucher is personal to the tenant family and moves with them from unit to unit. The rental assistance does not run with the unit, meaning that a tenant can leave their housing and keep the rental assistance. But that doesn't mean that an eviction is without consequence for a tenant in the voucher program. If a family in the voucher program is evicted from a subsidized unit for a serious violation of the lease, federal regulations provide that that leads to a mandatory termination of the family's participation in the voucher program. Before moving on to discuss a few more subsidized housing programs, I want to share one example of a tenant family in the Housing Choice Voucher Program whose housing and subsidy were threatened. This client's name is Josie, and she lives with her husband, her disabled adult child, and her 2 minor children in an apartment in Chicago subsidized by the voucher program. Josie was facing potential eviction due to alleged non-payment of rent in the amount of $10,000. However, Josie's family was very low income, and their rent portion was only $43 per month. Clearly, the amount of unpaid rent that the landlord was seeking didn't make much sense. At $43 per month, it would have taken over 19 years for Josie's family to amass a rental debt that large. Josie's family was also dealing with some pretty bad conditions in their unit, including rodent and bed bug infestations, ceiling leaks, mold, and other issues. Finally, as I mentioned earlier, the family would face mandatory termination of their voucher if an eviction order was entered against them due to a serious violation of the lease. And non-payment of rent is always considered a serious lease violation. So in Josie's case, we're not so much concerned with maintaining her current housing, given how bad the conditions in the unit were, but we are concerned with avoiding the entry of an eviction order against her, which would jeopardize her family's subsidy. So given the facts in Josie's case, it was pretty easy for us to figure out that the landlord was seeking to evict Josie, not because she had not paid her share of the rent, but because the Chicago Housing Authority had not paid its share of the rent. When a voucher family lives in a unit with bad enough conditions, after the unit fails multiple inspections, the Public Housing Authority will eventually stop paying its share of the family's rent until the landlord addresses the problems and gets the unit back into a habitable condition. However, the voucher family is never responsible for the public housing authority's portion of the rent. The landlord is not permitted to seek that portion of rent from the family or evict the family as a result of the public housing authority not paying its portion. So we were able to successfully defend Josie in this eviction case, given that Josie and her family had not actually violated the lease at all, since it was the Chicago Housing Authority and not Josie's family that had been withholding rent. Josie's story gives you an idea of how important it is for tenants like her to have advocates in court who are familiar with the subsidized housing programs and how they work in order to effectively represent them. Another federal program, which represents an increasing share of the country's affordable housing stock, is the Low-Income Housing Tax Credit Program, or LIHTC. In the LIHTC program, federal tax credits are provided in order to incentivize development of low-income rental housing. LIHTC is administered not by HUD, but by the IRS. In LIHTC, the rents work differently than in the other three programs we've already discussed. There are rent limits imposed by the program, calculated using the area median income. But importantly, a tenant's rent is not calculated as a fraction of the tenant's actual income. This means that, generally speaking, a LIHTC unit is a much less deep subsidy than the other programs we've discussed so far. In LIHTC, the rental assistance is again tied to the unit, and a tenancy may be terminated only for good cause. Those are arguably the biggest and most significant subsidized housing programs we deal with, but just to give you an idea of how many programs are out there, I've listed several more on this slide. VASH, which stands for Veterans Affairs Supportive Housing, is essentially a voucher program specifically for military veterans and also includes supportive services. HOPWA, or Housing Opportunities for People with AIDS, as the name implies, provides housing assistance for folks living with AIDS. The Continuum of Care program provides rental assistance and supportive services for folks who are unhoused. HOME is a federal block grant to states and localities, which is used to finance affordable housing for low-income individuals. And then there are various state and local programs, including the Chicago Low-Income Housing Trust Fund, which subsidizes units in the city of Chicago, and the Bridge Subsidy Program, which is a state tenant-based rental assistance program for formally institutionalized individuals with disabilities. Now that you have a bit of a foundational understanding of the different subsidized housing programs that exist, I want to provide a few examples of how the eviction process can differ within the different programs. This can get super specific and technical, and there's obviously no need for you to memorize this stuff, but I just want to give you an idea of how the programs can differ. One thing to know before I discuss some of these differences is that in most cases, a landlord is required to serve a tenant with a notice of termination before the landlord can file an eviction case against the tenant in court. The purpose of the notice of termination is to inform the tenant of the reason for the termination of their tenancy, and in some cases, provide the tenant with an opportunity to remedy or cure the problem. The notice has to specify a time frame, and the landlord cannot file a court case until the time frame specified in the notice of termination has passed. The regulations governing federally subsidized housing programs differ a lot in terms of the requirements for the notice of termination. For example, in public housing, if a public housing authority is seeking to evict a tenant due to alleged non-payment of rent, the notice of termination has to provide the tenant with 14 days before an eviction case can be filed, and the tenant can pay the delinquent rent within that period of time in order to avoid a case being filed. For other alleged lease violations in public housing, state law determines the time frame for the notice of termination. By contrast, in project-based Section 8 housing, state or local law determines the notice period for both non-payment evictions and evictions for other lease violations. However, we can and do argue that based on a procedural protection that I'll mention later, the notice of termination actually should provide the tenant with at least 10 days before an eviction case can be filed. Lastly, for tenants in the Housing Choice Voucher Program, state or local law determines how many days notice the notice of termination needs to provide. In Illinois, a notice alleging non-payment of rent has to give a tenant at least 5 days notice. A notice alleging other lease violations has to provide at least 10 days notice and at least 30 days notice for no cause terminations. The programs also differ in terms of how the notice of termination is required to be served on the tenant by the landlord. In public housing, a notice of termination has to be served by personal service or substitute service or US mail. In project-based Section 8 developments, but only some of the project-based Section 8 programs, the notice has to be served by both US mail and one other method, personal or substitute service or posting. In the Housing Choice Voucher Program, this state law governs the method of service of the notice of termination. The last example I'll share in terms of how the regulations governing the different federal housing programs can differ is additional procedural protections in place for tenants facing potential termination of their tenancy. In public housing, tenants are entitled to avail themselves of a pretty significant grievance process prior to an eviction court case being filed. That grievance process includes both an informal grievance meeting with the tenant's property manager, as well as a formal administrative hearing. The tenant has to be allowed to exhaust the administrative grievance process before an eviction case can be filed against them in court. In the project-based Section 8 programs, tenants are entitled to 10 days to discuss the proposed termination with their property manager. This is why, as I mentioned earlier, we often make the argument that a notice of termination served on a tenant in a project-based Section 8 development actually needs to provide the tenant with a minimum of 10 days notice. Otherwise, the tenant doesn't actually receive the benefit of the 10 days to discuss if the landlord is able to file an eviction case against them before the 10 days have passed. Finally, for the Housing Choice Voucher Program, the only procedural protections in place around the eviction process are those provided by state law. So we've discussed a few ways in which the eviction process differs within the subsidized housing programs. And I want to provide an example of how these specific aspects of the programs come up in our work. This client's name is Mandy. Mandy is a tenant with mental health disabilities living in supportive housing in Chicago. She was facing threatened eviction due to alleged noise violations, which were related to her mental health disabilities. The building utilizes various layered subsidies, which supportive housing buildings often do. One aspect of our work in the housing practice group is oftentimes having to conduct extensive research to try to determine what specific subsidies are at play in the developments we encounter. In Mandy's case, we submitted multiple Freedom of Information Act requests to the Illinois Housing Development Authority and the City of Chicago in order to suss out the subsidies that were involved. Eventually, we were able to determine that Mandy's building receives home funding, which is that federal block grant program that I mentioned briefly a couple of slides ago. One interesting quirk about the home program is that it requires landlords to provide tenants with 30 days notice prior to the filing of an eviction case in court, which is more than even tenants in public housing or the voucher program are entitled to. In Mandy's case, she had received only a 10-day notice of termination from her landlord. So the property had not followed the regulations governing the federal subsidy that it receives. So we were able to file a motion to dismiss on the basis that the notice of termination on which the eviction case was based was defective. That motion was litigated pretty heavily, but it eventually led to us being able to save Mandy's housing and her subsidy. Again, Mandy's story illustrates how a tenant in subsidized housing really requires representation by a specialist with a deep knowledge of the various programs to ensure that the tenant receives the full benefit of the rights and remedies available to them under the subsidy program. So far, we've spent a lot of time discussing evictions, and evictions do make up a large chunk of the work that we do in the housing practice group at Legal Aid Chicago. But there are other problems that families in subsidized housing face that we also assist with, and I want to discuss a few of those briefly. First, because many tenants living in subsidized housing are entitled to have their rent calculated as a portion of their adjusted monthly income, recertification and rent calculation problems can arise. In other words, property managers and public housing authorities can make mistakes in calculating the family's monthly rent, and the tenant can be asked to pay more than they should have to. Legal aid advocates can intervene to advocate for these mistakes to be corrected in order to make sure that our clients are able to retain as much of their limited monthly income as possible in order to be able to meet other monthly expenses. Another issue that we frequently encounter among families living in subsidized housing is accessibility for folks with disabilities. Accessibility can take many forms. A pretty straightforward example is that for a tenant with limited mobility or a tenant who primarily uses a wheelchair, we can advocate for that family to be transferred to a physically accessible unit, meaning a unit on the first floor or a unit in an elevator building, in order to ensure that the person is able to independently access their unit. Another issue of accessibility, though, is when a tenant with mental health disabilities faces potential eviction as a result of symptoms of their disability. This was the case in the example I mentioned earlier, Mandy, who was facing eviction for noise violations that were connected to her mental illness. For Mandy, we can argue that if Mandy gets into treatment to ensure that future lease violations don't continue to occur, the landlord should overlook her previous lease violations, which occurred as a result of her disabilities, and no longer seek termination of her tenancy. Next, as I've alluded to a few times during my presentation so far, tenants in the Housing Choice Voucher Program can face an administrative subsidy termination process that is separate from the eviction process. The Housing Practice Group represents families facing termination of their voucher, both in negotiating and advocating for the Public Housing Authority to stop seeking to terminate the voucher, and representing the tenant at their administrative hearing if the process gets to that point. As I mentioned briefly earlier, some tenants in subsidized housing, and frankly, some tenants in unsubsidized housing, face poor conditions in their units that threaten health and safety, such as mold infestations or other issues. The Housing Practice Group can assist tenants in addressing these issues. Finally, tenants in subsidized housing can face discrimination, whether it be on the basis of race or some other protected characteristic, or a voucher holder encountering resistance from potential landlords who don't want to accept their subsidy. I last want to briefly review a couple of special protections that exist for families in subsidized housing. One special protection for families in subsidized housing is VAWA, or the Violence Against Women Act. VAWA is a piece of federal legislation that protects victims of domestic violence, dating violence, stalking, and sexual assault. VAWA doesn't apply to private rental housing, but it applies to most federally subsidized housing. VAWA protects survivors from eviction and subsidy termination on the basis of the violence they have experienced or reasons related to the abuse. VAWA also allows for survivors who have experienced violence in their residential units to receive an emergency transfer to a different safe unit. Finally, we can use VAWA to advocate for a housing choice voucher to be bifurcated, meaning that an abuser would essentially be kicked off of the voucher so that the survivor can continue to benefit from the housing assistance without having to live in an unsafe environment with their abuser. Finally, one other special protection I'll make note of for families in subsidized housing are source of income discrimination protections. In Chicago and Cook County, local ordinances, namely the Chicago Fair Housing Ordinance and the Cook County Human Rights Ordinance, prohibit discrimination in housing on the basis of source of income. Source of income is defined as the lawful manner by which an individual supports themselves and their dependents. Source of income protection can be used to prohibit a housing provider from refusing to rent to someone whose income comes from Social Security or unemployment benefits as opposed to wages from work. But it also extends to the use of housing choice vouchers and other subsidies. Federally, source of income discrimination is not prohibited. In many places in the US, housing providers are permitted to refuse to accept a tenant with a voucher simply because they don't want to work with the voucher program. But here in Cook County, a housing provider cannot refuse to accept a tenant with a housing choice voucher on that basis alone. So the Housing Practice Group also assists voucher holders who have experienced source of income discrimination. All right, at this point, I'm going to read the CLE code that you'll need to enter into the link that's in the chat in order to get your CLE credit. It's there on your screen, and I'll also read it. It's 206121. Again, 206121. With that, I'm going to turn it over to Carrie Beyer from Legal Aid's Consumer Practice Group. She's going to discuss bankruptcy and how bankruptcy can be used as a tool to assist families in subsidized housing.
Thank you so much, Catherine, and thank you all for being here today. We really appreciate your attendance and to hearing more about the work that we do. And if anyone has any questions, please you're encouraged to put them in the Q&A section. We'll be happy to answer them at the end. My name is Carrie Beyer. I'm a senior attorney in the Consumer Practice Group, where we're focused on bankruptcy, talking about bankruptcy today and how that intersects with families living in subsidized housing. So I'm going to start with a brief overview about the different types of consumer bankruptcies that we work on, and then talk about how they relate specifically to families living in subsidized housing. So to start out with, first, I want to talk about, there's basically two main types of consumer bankruptcy. There's Chapter 7 bankruptcy and Chapter 13 bankruptcy. So Chapter 7 bankruptcy is called liquidation. And as the name might imply, it means that a person has to, their assets can be taken and sold to pay their debts. And in exchange for that, for taking their assets and having them sold, their debts are then discharged or erased. So they're no longer responsible for that debt. So basically, when our clients are encountering, thinking about a Chapter 7 bankruptcy, the first thing we need to know is what are their assets. So many of our clients don't have a house or don't have a car, so they don't have any assets that can be sold. And there are also a few exceptions as far as assets go. You are able to keep a limited amount of assets, such as small amount of savings, like up to $4,000 in savings and things like that. You are able to keep it and are not sold in bankruptcy. So for many of our clients, their assets are, below the limits of what can be taken and sold from them. But when they file a Chapter 7 bankruptcy, they get their debts erased or discharged. So it's a very good benefit to them. There are a few kinds of debts that cannot be discharged in a Chapter 7 bankruptcy. Some examples that a lot of people are familiar with is student loans. There's also tax debts, parking tickets, and child support are just a few other examples of debts that cannot be discharged in a Chapter 7 bankruptcy. And a client can only file a Chapter 7 bankruptcy once every 8 years. So it is a limited tool, but an extremely useful one for many of our clients. The next type of bankruptcy I'd like to talk about is a Chapter 13 bankruptcy, and that is called a reorganization. And for a client to be in a Chapter 13 bankruptcy, they need regular income because they're able to keep all their assets, but they have to repay at least some part of their debts through a monthly payment plan for 3 to 5 years. So they propose their own payment plan or plan of reorganization that explains how they're going to pay back at least some portion of the debt that they have. Chapter 13 bankruptcy is very useful for clients who have leases, mortgages, or car notes that they've gotten behind on, because they can use their payment plan to catch up on those payments, or as we would call it, like to cure a default on those contracts. So for example, we'll talk a little bit about a residential lease situation, but if a client is behind on their rent payments what they do is when they file a Chapter 13 bankruptcy, then they are responsible then for making their ongoing regular monthly rent payments. But then they make an extra payment to the bankruptcy plan, under their bankruptcy plan, that goes to catch up on the rent payments that they've missed. And they can do that little by little over the 3 to 5 year period. Another benefit of a Chapter 13 bankruptcy is that you can discharge more types of debts than in a Chapter 7 bankruptcy. Like, for example, parking tickets can be discharged in a Chapter 13 bankruptcy, but not in a Chapter 7 bankruptcy. So that's called a super discharge, and that's another benefit available to someone in a Chapter 13 who chooses to do a repayment plan instead of a liquidation. So now I just want to talk a little bit about how this intersects with families living in subsidized housing. And in a Chapter 7 bankruptcy, it's kind of useful in a very narrow but really important way for some of our clients. As Catherine mentioned, that if a client has a subsidy, but they owe rent, and a landlord, a landlord sues them and gets a judgment against them for the past due rent, then their voucher can be terminated, or their participation in the program can be terminated. So one of the ways that we can use a Chapter 7 is to avoid that situation. A Chapter 7 bankruptcy itself doesn't stop an eviction case from going forward. But if, for example, a client has a voucher and they've moved to a new unit, but they owe rent to a prior landlord, and that, that rent could threaten their eligibility to keep their voucher going forward, what they can do is file a Chapter 7 bankruptcy, and they can discharge or erase that debt to the prior landlord. And then they're not going to be threatened as far as their eligibility to continue in the program because of that rental debt that existed. And the bankruptcy laws also provide that the government cannot discriminate against somebody because they filed a bankruptcy. So the fact that they're filing a bankruptcy to discharge the rent, the past due rent that was due, does not make them, ineligible to continue with the housing voucher. So it's a very useful tool for clients in that kind of narrow situation where they have past due rent out there from a prior landlord, and if they discharge it or erase bankruptcy, then they continue to be eligible for their voucher or their subsidy. In Chapter 13 bankruptcy, there's a few more options for families living in subsidized housing that are really important and useful for them. So as I mentioned, in a Chapter 13 bankruptcy, you can cure a default on a lease, which means that if you missed rent, you're past due on your rents, you can use a bankruptcy payment plan to catch up on that rent little by little, over time, taking up to 5 years to catch up on it. So it's very helpful to people who can eventually pay back the rent that they've missed. They need time to do it. That's what the Chapter 13 gives them. They have to file a Chapter 13 case before their lease is expired under state law. And this is where we are able to build on some of the terrific advocacy that our consumer housing group and other legal aid advocates across the nation have done, because whether a lease is expired is a question of state law. And we're looking at those notice periods, the notice of termination that Catherine mentioned comes into play. So we're able to take some terrific case law that they've developed and use that to help us show the bankruptcy court that the lease is not expired. And I'm going to talk about that a little bit more when I go into a client example of how we've used that in bankruptcy court. Another reason why a Chapter 13 is so valuable for families living in subsidized housing is because, as Catherine mentioned, they have this endless right to a lease. So their lease continues year after year. They have the right to renew the lease. So as you can imagine, if you had a 1-year lease with a landlord and you wanted to do a repayment plan that's between 3 and 5 years, the lease would terminate before before the client would have an opportunity to actually catch up on the past due rents. And of course, the landlord would have no obligation to continue leasing that apartment to our client, because if they don't have a right to renew the lease, it would just be over and they would have to move. So you're not really preserving the housing for that client for the long term. But because our clients living in subsidized housing have these endless leases and they have the right to renew them year after year, they're able to take the time to catch up on past due rents, as long as 3 or 5 years, and keep themselves in their units. Though there is one thing that's an area too where we have some pushback from landlords, and we do have some litigation in bankruptcy court, is that the bankruptcy laws require that they promptly cure their defaults on their lease. And what this means exactly kind of depends on all the facts and circumstances of the case. So the good thing is that we can be able to go to the bankruptcy judge and explain to them everything about the client's situation, and explain to them why they need time to catch up on the payments that they missed and keep their lease. So it gives us a good opportunity to be able to have the judge examine the client's individual situation and address it from there. So just to give a very quick example of how this works, in a Chapter 13 case, I wanted to talk about this client whose name is Anna, and what she came to us, and she had a project-based Section 8 lease. So as Catherine was explaining previously, if it's a project-based lease, that means that if that lease ends, the client no longer receives the subsidy. She can't take that subsidy to a different unit. It runs with the unit. So she came to us because she was behind on her rent. And she had received a 5-day notice terminating the lease. And it was interesting because she actually came to us after the 5 days had expired, but her lease had this provision that Catherine was talking about too, where she had 10-day right to discuss with management the termination of her lease. So we were able to file a case for her in bankruptcy court before the 10 days from the date that she got a notice of termination. And we used the terrific case law that housing advocates had developed, saying that, the right to discuss your lease for 10 days has no meaning if the lease is terminated after 5 days. We were able to show the judge some terrific cases that had found that it really means you have 10 days essentially to before the lease is terminated, because you can discuss and work out something with your landlord in that period. So the judge agreed, and she said that the lease was not terminated at the time we filed the bankruptcy, and our client was able to go forward with the Chapter 13 bankruptcy. Now, she had enough income where she could pay her regular rent each month, and then she would pay a little bit extra each month toward her bankruptcy payment plan. And then that money that she paid toward her bankruptcy payment plan would go first to catch up on the rent that she was behind on little by little over time. And then it also would go, some small portion of it would go to pay her other debts. And then at the end of the case, she would be caught up on her lease, and all her other debts would be discharged or erased. So she kind of starts over, fresh start from the bankruptcy. So that is an example of a successful Chapter 13 bankruptcy case that we were able to use to help save a client's subsidized housing. And finally, I just wanted to mention that there were a couple of COVID-19 bankruptcy protections, specifically that were specifically, passed as part of the CARES Act to protect bankruptcy clients. One of them was that there was, once there's various eviction moratoria went into place, the law specifically said that, just because someone is in a bankruptcy does not make them mean they're not eligible for protection under an eviction moratoria. So they wanted to avoid a situation where landlords would be, running into court and arguing, well, the moratorium doesn't apply to this person because they filed for bankruptcy and they're involved in a bankruptcy. The law makes clear that even if you're involved in a bankruptcy, you still get the protection of any sort of general eviction moratoria that has been passed. So that was really helpful. And then the other provision in the CARES Act that was very useful for clients who are involved in bankruptcy is that if they had a bankruptcy case going, a Chapter 13 where they were in a payment plan, at the time that the pandemic began, then if they suffered a hardship during their bankruptcy case and were unable to keep up with their bankruptcy plan payments, they could ask for an extension of their bankruptcy plan, and they could actually have up to 7 years to repay their debts instead of the normal 5, due to the hardship that they had experienced, as long as the hardship was related to the pandemic. So those are 2 special protections that were very helpful to our clients. So that's all I'm going to talk about today. I'm happy to answer any questions, and I'd like to turn it over to Melissa.
Thank you so much, Carrie. And this was such a detailed presentation, and you and Kate did a wonderful job of giving an overview of these complicated issues and how we at Legal Aid Chicago assist families. And I'm inspired to work alongside you. And I want to talk a little to those of you who are watching about how you can get involved in our work. At Legal Aid Chicago, we have over 20 different pro bono opportunities, and we simply could not meet the needs of our clients without the help of our volunteers who work alongside us to serve our clients and help bring about justice for all. We have a variety of opportunities available, spanning subject matters and offering everything from a short-term commitment of a couple of hours to a longer-term engagement. We have opportunities for non-attorneys and attorneys, and many of our projects have an immediate need for volunteers. One of those opportunities is the now virtual eviction brief advice desk. As Kate mentioned, there are situations where clients are facing eviction now, despite the eviction moratorium, and we could absolutely use your help in assisting these tenants. Our goal in this project is to help tenants by advising them of their rights, to make referrals, and to help them reach a resolution with their landlord, which in most cases is a win for both sides. We have a training available on demand to provide a background on the law and how eviction court works. There is no obligation to represent a tenant beyond your shift, in court or otherwise. And you can sign up for a shift at your convenience, and shifts are just 1 hour. So you can find more information about all of our volunteer opportunities on our website. And you're welcome to reach out to me with any questions you have about any of our opportunities and how you might be able to help. And I'll turn it back over to Kate Schenk now.
Thank you so much, Melissa. And thanks also to Marshall and Kate and Carrie for sharing your work with us. So this concludes the planned content portion of today's presentation. In a moment, we'll start the Q&A portion. But before we do, just a quick reminder, we would appreciate it if you could fill out a brief survey about the presentation. So to do that, or if you'd like CLE credit in addition, click on the link in the chat and fill out the form. So please note that the certificates of attendance will be sent out within the next week or so of attending. We'd love it if you join us next week for our session discussing the needs of families involved in the child welfare system. The panelists are going to remain here to answer your questions, which you should type into the Q&A at the bottom of the screen. I know we have a lot of questions that have come in, so Melissa, could you please take us through them?
My pleasure. These are some wonderful questions, and we'll do our best to get to them. So the first question is for Catherine, and the question is about, you mentioned a couple times, endless leases. So can an endless lease be terminated if the tenant no longer meets income requirements?
Thanks for that question. You know, these things can really differ based on the subsidy program, which is kind of my answer for everything that we've discussed so far. But for like public housing and project-based Section 8 housing, probably if their income reached a level where they no longer qualified for a subsidy, they would be expected to pay market rate rent in the unit, but that would not be necessarily a basis to terminate their tenancy. In the Housing Choice Voucher Program, I mean, they don't have endless lease agreements in the voucher program, so I guess the question doesn't necessarily apply. But if the tenant's rent reaches a level, or sorry, their income reaches a level where they no longer qualify for a subsidy, after 6 months of the Public Housing Authority not paying any subsidy on the tenant's behalf, they are terminated from the program. And then for other programs, the answer might differ.
Great. And there's a question here about sort of the order of things. You know, if someone's voucher is going to be terminated, is it usually after an eviction order is entered? Is it before? How does that work in relation to having an eviction and also having your subsidy terminated or your voucher terminated?
Well, it really depends on the public housing authority. Sorry, this is such a lawyer answer. I would say that a lot of public housing authorities will initiate the termination process while the eviction is pending. But if the reason that they're terminating the voucher is an eviction order that was entered due to a serious violation of the lease, and that's the way that it's a mandatory termination, they really couldn't do it until the eviction order was entered. But that being said, oftentimes, whatever the reason for the eviction is can also independently be a reason for the voucher termination, separate and apart from the eviction order itself. And so the housing authority might try to terminate the voucher, not just for the eviction order, but for the underlying reasons behind the eviction order. And so they could still try to terminate the voucher either before an eviction order was entered, or even if the tenant won the eviction, theoretically, the public housing authority could still try to proceed with the termination.
Thank you, Kate. And Carrie, this is a question for you. So you mentioned filing bankruptcy. So would you talk about the impact on one's credit score as a result of filing bankruptcy?
Yes, I can explain that a little bit. So as you might imagine, a bankruptcy is considered a negative event on your credit. And a bankruptcy filing will stay on your credit report for up to 10 years. So it does stay longer than a delinquent account, which typically stays on your credit for up to 7 years. But, you know, as with anything else, you know, any other adverse events on your credit score, the impact on your credit report, the impact on your score depends on how much time has passed since the event. The most recent, you know, activity, let's say, on your credit report tends to have the most impact. So as time passes, the impact of the bankruptcy will begin to minimize, but it is considered a negative event for credit reporting purposes.
Kevin, you mentioned about a family that was facing conditions issues and talked a little bit about that. So what are someone's options if they're living either in a CHA owned property or a project-based Section 8 where they're dealing with poor conditions?
Thanks. It's a really hard issue. I think, you know, congressional appropriations for maintenance in subsidized housing have not kept up with the need. I will say that. And so there is a lot of deferred maintenance in publicly subsidized properties, and there's not an easy answer to it. I would say that people can always call Legal Aid Chicago and be screened to see if theirs is a case that we would consider. And you know, there are legal tools that can be used to litigate these problems. I think the problem is that the need for it far outpaces the resources that we or any other agency have to address the problem. And so, I mean, unfortunately, I do not have an excellent answer to that question.
Thanks. And just piggybacking off of that, you mentioned calling us or being referred to us. And so if there's anybody who would like to have a client call us, our main intake line is 312-341-1070. Clients can also apply online at legalaidchicago.org. And there's a question here about how we receive referrals, and the answer is from all sorts of places, including community partners, including public housing authorities who might refer people to us, housing counselors, etc. But we are definitely plus if they have individual questions about their situation. Okay, just really good questions here. And so Carrie, in particular, you know, you mentioned Chapter 7 and you mentioned Chapter 13. Can you talk about how long it takes to complete each of those processes?
Yes, absolutely. So a Chapter 7 bankruptcy is usually a little bit more short term, but it depends on whether you have assets. So that's part of might have an impact on how long the case lasts. But say for an example, we file a case for a client that does not have assets. The case would be open for about 4 to 5 months, and then it's over and done with. And the good thing about bankruptcy is that the relief is immediate. As soon as you file a case, all your creditors have to stop taking action against you. And that comes, on day one. So from there, it's just a matter of finishing the process of bankruptcy and getting your debts discharged. But you can get some relief right away. In a Chapter 13 bankruptcy, unless you're paying all your debts in full, there is a requirement that you are in the bankruptcy for a minimum of 3 years or 36 months. So it has to be at least 3 years, and then it can be up to 5 years that you are in it, depending on what you're trying to repay through your repayment plan and how much you have to pay and what you can afford to pay. So it can range between the 3 and 5 year period.
Great. And can you comment a little bit on getting a filing together? So you mentioned in your case example, someone had been given a 5-day notice. You've argued successfully that actually gives them 10 days to do something. So is it really possible to get a bankruptcy filed in the 10-day period that someone has?
It is, and it's tricky, but the bankruptcy code is set up, the bankruptcy laws are set up to allow for what's called an emergency filing, when something really needs to be filed right away, and that relief of having the creditors stop everything can come right away by filing just a few pages. And as you might imagine, actually completing a bankruptcy is about 40, 50 pages. It's like a big hunk of paper like this, but you can just with a very few pages get a case started and get some relief from creditors right away.
Wonderful, thank you. Love sort of springing into action, I picture you. So, and Kate, regarding the notice of termination for procedural protections, what happens when there's alleged criminal activity? Is there a grievance procedure, and does the landlord have to provide proof of the alleged criminal allegations?
Yeah, so I imagine that this is referring to a little notation that I had on the slide that said grievance protection, but not for criminal activity. So the grievance procedure is, first of all, only available for tenants in public housing. And there are federal regulations that indicate that a public housing authority is not required to provide the grievance process for tenants whose tenancies are being terminated as a result of criminal activity if the state law procedure, the procedure that's already in place under state law, meets minimum due process requirements. And there's been a determination by HUD that the court procedures in Illinois do meet minimum due process requirements, such that the public housing authorities in Illinois and Chicago are not required to provide a separate grievance process. And so the answer is yes, the landlord is still supposed to provide proof, because there's still a court procedure that's in place. They still have to provide the notice of termination. They still have to bring the tenant to court. They can't just lock them out. And so if the tenant exercises their right to a trial, and in Illinois they're entitled to a jury trial, then the landlord or the property manager is required to provide proof that the criminal activity occurred and not just allege it.
Thank you. And can you talk a little bit about your success in those, or what your experience is, or if you've had success in those informal grievances for formal grievance procedures? Are you able to resolve things before, in that 10-day period, or at that meeting with the property management company or the PHA?
I'd say it really depends on the willingness of the property manager. A lot of times evictions, a tenant might get a notice with a stated reason, but there might be a lot more going on there between the tenant and the property manager. And so, depending on the tenant and depending on the property manager, the willingness to work with the tenant can really differ. So yes, the answer is sometimes we do resolve these things at an informal meeting, and sometimes we don't. And the nice thing about a formal grievance for tenants in public housing is that there's an impartial party, essentially a judge, not actually a judge, like an administrative law judge, who hears from both sides and makes an independent determination before the case ever gets to court. So, we don't actually do a ton of those, just because, the number of tenants in public housing are sort of dwindling over time. Other programs are overtaking public housing. And so, and if something is resolved at the informal stage, then a formal grievance hearing becomes unnecessary. But again, it is really nice to have that impartial individual there, because then it's not up to the property manager's goodwill to resolve the case.
Great, and Marshall, this is actually a question for you, if you wouldn't mind jumping in. You had mentioned in a previous answer something about opportunity areas where payment standards can be a little bit higher for public housing. And so where can one receive information about opportunity areas and exceptional payment standards?
Okay, Melissa, you can find out about that with the CHA for one, as a housing authority. You would inquire with the mobility program. So the mobility program is there to assist residents in finding units in opportunity areas. In the opportunity areas, the voucher amount can go up to, I believe, 150% over the regular standard. And the question that she had was about, or the comment was about the values of the voucher, not really supporting the participants to be able to find decent housing. The one drawback that I've come across sometimes is with some landlords, especially in certain areas, north side, that although, especially if they're with the realty, they cannot say, we don't accept Section 8 vouchers. However, there are ways, if they do say that, it could be trouble, but sometimes there are ways to try to get around that. But other than that, yeah, to increase your amount on your voucher, you can reach out to the mobility program at the Chicago Housing Authority if that's applicable to your situation, and you want to let them know you're interested in opportunity areas, and then you could take advantage of the exception payment standard. Hope that helps.
Thank you so much. And sort of while you're unmuted already, and sort of, Catherine, you might want to jump in on this as well, but sort of, is it hard to get a voucher, right? I mean, it sounds like, can you talk a little bit about wait lists and opportunities on how people can apply to get on subsidized housing if they're not already a recipient?
Well, in Chicago, I think it will be some time before you would be able to obtain a voucher. I think the last one that they had a few years back, they had a lottery, something like 40 or 50,000 vouchers issued. So the wait list is pretty long, but you can go outside of Chicago, and you just have to kind of keep your eyes and ears open as to who is open, their wait list is open or might currently be issuing vouchers. It would probably require relocating. For example, if you want to stay in Illinois, you might have to go downstate to get a voucher. If that's your goal. You'd have to stay down there at least a year, and then you could port out to wherever you wanted to go. In some cases, though, it's not that far. For example, maybe Waukegan, maybe their wait list is open, or Joliet, maybe their wait list is open, and you don't have as long a wait to obtain a voucher. But the city of Chicago, and also I would say Cook County Housing Authority as well, no, you're going to be waiting a long time to try to get a voucher there.
Right. Just to be clear, that not only is the waiting list long, but the waiting lists are closed. And so occasionally they open them for like a week or a 2-week period, and then everybody scrambles to get their name on the list. But right now they're closed, and they have been for some time. The Housing Authority of Cook County actually did open their waiting list briefly last year, but they're both closed at the moment. But as Marshall said very wisely, it is easier to get on lists elsewhere, but you are supposed to be living in the place where you're on the list.
Great, and that actually is a great transition to answer the question, what kind of assistance or what kind of rights do residents in Will County have, or is it eviction avoidance available to residents in Will County? And I don't know if Kate, if you want to jump in on this, but I will say, laws differ by county, laws differ by city, though many of the protections that you talked about were federal. If I'm not overstepping in saying that, and that there are state protections as well for residents, and there is, a LSC funding recipient to provide legal aid to residents of Will County. It's Prairie State Legal Services. They're our partner in this work in many ways. And so if there's a particular need there, then perhaps they could help with that. Anything to add there?
I mean, yeah, I would just say, I mean, I guess I don't know what's meant by eviction avoidance. There's certainly a court, they still have to go to court and get a court order, and the sheriff has to enforce that order before a tenant can be evicted. A landlord is not entitled to just lock somebody out. And yeah, I think almost everything that I discussed was either federal or state, so it would apply to Will County. I did mention a few things that were local ordinances, like source of income protection, that don't apply in Will County, but that's obviously not applicable to eviction avoidance.
Great. And just to answer this question real quick, well, on the related topic, which is, does the Chicago residential landlord tenant ordinance apply to subsidized housing?
Yes, local laws still apply. Yes, so I mean, I think that there might be some argument to be made that if there's a direct conflict, that there might be some federal preemption. But in most cases, the landlord has to follow not only the federal regulations, but also state and local laws.
Great. And Carrie, you mentioned specifically using bankruptcy as a tool when a resident owes rent. What about when someone owes utilities? What are the options there if they're up to date on rent, or their rent happens to be zero, but they're behind on utilities?
Well, utility bills are another area where bankruptcy can be really beneficial for people, because if you are behind on utilities and or client is behind on utilities and being threatened with a shut off of their utilities, by filing a bankruptcy, you can actually discharge or erase the amount that you owe on that particular utility bill and kind of get to start fresh again with a new billing cycle. And that also stops them from shutting your utilities off. So if you really obviously need your electricity or your gas or water, these are all, bankruptcy is a way to stop that from being shut off and discharge the amount that you owe or erase it and let you start fresh again. So it is very useful. And as some people may know, if you have a voucher and you don't keep your utilities turned on, that can sometimes be a basis for a housing authority to terminate your voucher. So it's very important to consider your options if you're in that situation, or a client or someone you'd like to refer to us in that situation. Bankruptcy can be a good choice in certain circumstances.
Great. And we're sort of getting to our time, so we'll wrap up just shortly. But first, Kate, there's a lot of confusion because there are management companies, and that's confusing about whether they are the Chicago Housing Authority. And so can you talk a little bit about how management companies that the Chicago Housing Authority use fit into subsidized housing? Are the management companies empowered to evict tenants?
Yes, they're an agent of the CHA in that case. So the CHA is the owner, and they hire these management companies to manage their properties. And so sometimes when you see an eviction filing for somebody who's in public housing, sometimes CHA is listed as the plaintiff, and other times it's the management company. And I have to tell you that I don't actually know why. Like, I don't know in what cases CHA is the plaintiff, and in other cases it's the management company. But yes, as the agent of the owner, they are entitled to evict. And typically, you know, my experience is that if I'm dealing with an in-house CHA attorney on an eviction, they will really defer to their property manager and what the property manager wants when we're negotiating possible settlement in the case.
Great. Well, I think that's all the time we have for questions. So I'll turn it over to Kate Schenk to close us up.
Thank you, Melissa. Thank you, everyone. What thoughtful and really engaging questions, and just really appreciate our expert panelists answering them. Really appreciate all of you being here today. Enjoy the rest of your afternoon and hope to see you next week. Thanks again.